Hello and welcome to SanDemy. This series explains housing law, standards, and the Renters' Rights Act in clear, accessible language without getting lost in legal jargon or headlines.
We're not here to give legal advice or take sides. Instead, we focus on how the housing system actually works in practice for tenants, landlords, letting agents, and local authorities.
In this episode, we're looking at what protections do tenants have under the Renters' Rights Act.
And it is a huge topic, isn't it? I mean, it's one that causes a lot of anxiety on all sides.
It really does. You see the headlines and it feels very black and white. It's either a disaster for landlords or a revolution for tenants.
Exactly. But when you actually look at the legislation itself, the reality is far more technical and, dare I say, more practical.
Okay, practical is good. I think we can all agree on that. But I suspect for a lot of our listeners, the word practical gets a bit lost. It feels like this is just a whole new book of rules. Is that right? Or is it more of a tweak to what we already have?
That's a very good way of putting it. Look, the Act is definitely strengthening protections. That's true. But its real value, I think, is how it clarifies the whole journey.
The journey.
Yes, it sort of answers the question, okay, so what happens next? You're a tenant with an issue, or you're a landlord facing a complaint. The Act tries to map out that pathway from the initial concern all the way through to, hopefully, a resolution. It's much more about the process than it is about the penalty.
So let's get into that process, because there is a bit of a feeling out there that this act just wipes the slate clean. But is it a totally standalone thing, or does it, plug into the system that's already there?
It's very much the latter, and that's a really crucial point. This Act does not operate in a vacuum. You have to remember, we already have a pretty robust set of housing standards in the UK.
You mean things like the HHSRS,
Yes.
health and safety ratings?
Exactly that. We have the HHSRS, which looks at everything from damp and mold to trip hazards. We have legal management duties, gas safety checks, electrical reports, all of that. None of that has gone away.
So the basic definition of what makes a home safe or unsafe hasn't actually changed?
Not at all. The what hasn't changed. A dangerous boiler was dangerous 5 years ago, and it's still dangerous today. Those standards are the benchmark. What this Act changes is the how.
How we enforce it.
How we make sure those standards are met, yes. And a key part of that is making the system work without every single problem ending up in court or with a huge fine. That just wouldn't work.
I can imagine landlords listening will be breathing a sigh of relief at that. There's this fear that, a slightly loose doorknob could suddenly result in a massive penalty.
And that fear is, well, it's largely unfounded if you understand the framework. The goal is to be appropriate and proportionate. The system doesn't start by asking, how do we punish the landlord? It starts by asking, does this property meet the standard?
I like that word benchmark. It sort of takes the emotion out of it. It's not a fight between two people. It's just measuring something against an agreed standard.
That's the idea. And that brings us to the first step, because before anyone gets near a council officer or an ombudsman, there's that first conversation.
Right, the ground level. So let's get practical. I'm a tenant. I found a damp patch, or my boiler's making a strange noise. Under this new system, what do I actually do first?
Okay, first things first, please don't stop paying your rent. That never helps. No, the first thing to understand is that in almost all cases, issues start as complaints. They don't start as legal breaches.
Okay, hold on. Unpick that for us. Because in everyday language, those words sound like the same thing. If I complain, it's because there's been a breach, surely.
Not necessarily. A complaint is simply the act of raising a concern. It's the tenant saying, excuse me, something isn't right here. It could be about the property condition, like that damp patch. It could be about management. Maybe the agent isn't replying to emails. At that point, it's just a request.
So a complaint is really an opportunity.
Precisely. It's an opportunity for a quick, early resolution. A breach, on the other hand, is a confirmed failure to meet a legal requirement. But you often don't know it's a breach until the complaint has been looked into.
Can you give us an example?
Of course. Let's use your boiler. You send a text to your landlord. Hi, the boiler's making a funny noise. That's a complaint. At that moment, the landlord isn't in breach of anything. Boilers can fail. Now, if the landlord gets an engineer out the next day and it's fixed, the system has worked perfectly. There was a complaint and there was a resolution. No breach ever occurred because the landlord met their duty to repair.
I see. So the system is designed to make that initial conversation feel safer for everyone. The tenant isn't scared of being evicted for complaining, and the landlord can just, fix the boiler.
Exactly. It lowers the stakes. The whole system prefers early, informal resolution. It's faster, it's cheaper, and it's better for the relationship.
But we know it doesn't always go that smoothly. What happens if I send the text, "I've made the call," but 2 weeks later, nothing has happened? Or the landlord just says they can't afford it.
And that's when we move from that informal chat into what the new legislation calls clearer redress routes.
Okay. Redress. It's one of those official sounding words. What does it actually mean for someone just trying to get their heating back on?
It just means there are formal ways to sort out the dispute without having to go to court straight away. If the chat doesn't work, the act is bringing in and strengthening the role of the ombudsman.
The ombudsman. We hear that term in other areas like banking. It's basically a referee, right?
A referee with authority, yes. And the idea behind these routes is threefold. One, to bring consistency. Two, to ensure fairness, because you have an impartial third party. And three, to reduce the need for formal enforcement action.
So it's a kind of buffer zone.
I'd call it a filter. Redress is all about finding a resolution. It's not about punishment. It's that bridge between a simple complaint and full-blown enforcement.
And it can work both ways, I suppose. It's not just there for tenants.
Absolutely. This is a critical point for landlords. An ombudsman is impartial. They might look at a case and decide the landlord has actually met all their obligations. They can protect a landlord from, unreasonable demands just as much as they can help a tenant.
That makes sense. It stops the council's enforcement teams being swamped with every minor disagreement.
It does. It keeps the real heavy machinery of the state for the problems that genuinely need it.
Well, speaking of the heavy machinery, there has to be a line, doesn't there? A point where this approach of talking and mediating stops. When does actual enforcement happen?
And that brings us to the role of enforcement. And the key principle here, the thing you'll see in all the official guidance, is that it is a last resort.
Last resort. So it's not the default setting at all.
Not at all. Enforcement is still a vital part of the system, of course. We need it for the rogue landlords, for the criminal operators.
Yeah.
But it is not the starting point. Local authorities have very limited resources, and the law expects them to act proportionately.
So what are the triggers then? What takes a situation from needing resolution to needing a formal notice or even a prosecution?
There are, generally speaking, three main triggers. The first is a clear, serious breach of a legal requirement. We're not talking about a scuff on the paintwork here. We're talking about a significant failure.
Okay.
The second is ongoing non-compliance. So the landlord has ignored the tenant's complaint. Maybe they've even ignored a decision from the ombudsman. At that point, they're actively defying the system.
Right. That shows intent. It's not just an oversight.
Precisely. It becomes a conduct issue. And the third trigger, which is the most urgent, is where there's a direct risk to health and safety.
Ah, so this overrides everything else.
Immediately. If there's exposed wiring or severe mold affecting a child's asthma or no heating in winter, the council isn't going to wait. They have powers to step in and enforce safety standards straight away. The softly approach doesn't apply to immediate danger.
That's reassuring. I think people worry that a process means they'll be stuck filling in forms while their ceiling is about to collapse.
No, the system is designed to distinguish between a dispute and a danger.
So it all comes back to that word you used earlier, proportionate.
It really is the key word. The act reinforces a targeted, justified approach. You don't use a sledgehammer to crack a nut. The severity of the response from the authorities should match the severity of the failure from the landlord.
I think that makes so much sense. It feels less like a trap and more like a ladder. You only move up to the next rung of severity if the issue isn't dealt with at the level below.
That's a perfect way of describing it, yes.
Okay, so let's break this down for everyone listening. We've got tenants, landlords, agents, council officers. What does this framework mean for each of them in their day-to-day lives? Let's start with tenants.
For tenants, it's really about empowerment and security. The biggest single change is providing these clear routes to raise concerns without that constant fear of a no-fault eviction.
The Section 21 notice.
Section 21. For years, people have lived in poor conditions because they were too afraid to complain. With that gone and these pathways in place, the balance shifts.
But there's a responsibility there too, isn't there?
There is, yes. These protections operate within a framework. Tenants have to use the correct pathway. You need to provide information. You need to allow access for the repairs to be done. It's a two-way street.
Right, professionalizes the relationship. Okay, what about landlords? Many feel quite nervous about all this.
For landlords, I think the key word is predictability. Look, I know change can be unsettling, But this framework actually offers a lot of protection for a good landlord. It gives them what I sometimes call a paper shield.
A paper shield, I like that.
If they keep good records of complaints, how they responded, invoices from builders, if they can document that they acted reasonably and professionally, they have very little to fear from escalation. The system is designed to catch negligence, not good practice.
So good management is basically the best form of compliance.
It always has been, but now the legal framework more explicitly rewards it. It helps separate the professional landlord from the criminal one.
And finally, what about the councils? The local authorities who have to police all of this on what we know are often very tight budgets.
For councils, this framework helps them manage their resources more effectively. It helps them to triage cases.
Triage, like in a hospital A&E.
Exactly like that. You don't get the top surgeon to look at a grazed knee. Not every housing complaint needs a full enforcement investigation. Some just need signposting to the Ombudsman. These clear pathways help councils focus their limited staff and money where it's most needed, on the dangerous properties and the criminal operators.
It really clarifies the why behind it all. It's not just more bureaucracy for the sake of it, it's an attempt to create a system that actually functions from start to finish.
That is the ambition. To move from a system that could often feel a bit random to one that is driven by process and, above all, by proportionality.
It's fascinating when you break it down like that. It actually sounds quite sensible.
Well, let's hope so. The logic is certainly sound. It's about clarity, fairness, and safety for everyone.
That brings us to the end of this episode of SanDemy. We hope this has helped explain how this part of the housing system works and why the changes matter in practice.
This content is provided for general educational purposes only, does not constitute legal advice, and is not published on behalf of any local authority or organization. For specific situations, always refer to the legislation or official government guidance.
If you'd like to follow the rest of this series, you can subscribe to the channel for future episodes. In the next episode, we'll look at the landlord database and Ombudsman explained, oversight and accountability in renting.